debate now with David Rivkin, a Washington, D.C. litigator and a former counsel with the Reagan and Bush administrations. He is assisting the 14 state attorneys general with their constitutional challenge. And Richard Cordray, Ohio's attorney general, who this week announced that he believes these lawsuits have no merit. Gentlemen, thank you both for being with us. And David Rivkin, I'm going to start with you because you are representing the people who are putting the challenge forward. As I understand it, two main arguments here. One of them is that you believe it's unconstitutional to require people to buy insurance. Why is that unconstitutional?
It's unconstitutional both as a matter of a fundamental principle and relevant case law. As a matter of fundamental principle, key aspect of a constitutional architecture is that the federal government is the government of limited and enumerated powers. That point was made by James Madison in the Federalist Papers, who said that the powers of the federal government are few and well defined. The powers retained by the states are numerous and indefinite. If you have an infinitely broad Commerce Clause under which Congress can legislate, it would absolutely eviscerate state authority to have any independent regulation. And there's cases, very recent cases, 5-4 decisions, including Lopez, which struck down the Gun-Free School Zone Act, and Morrison that struck down key portions of Violence Against Women Act, that says very clearly, an opinion both written by Connor and Justice Kennedy, if we're still in the court.
These are recent cases.
Very recent cases that indicate that there have to be meaningful limitations on the scope of Commerce Clause. Otherwise, we'll swallow the rest of the Constitution.
And you're arguing that this requirement that people buy insurance exceeds that
Absolutely, because it doesn't regulate economic activities. It compels people to engage in behavior they do not desire.
All right, let me turn to Attorney General Cordray in Ohio. Why do you believe that it is constitutional?
Well, David is a top-flight lawyer. I've read what he's written on the subject, and he makes very creative arguments. But you'd have to find activist judges willing to tear up decades of settled precedent for these claims to succeed. The reality is that for 70 years since the Depression, the court has been very permissive in terms of letting Congress regulate interstate commerce. And of course, many things have become interstate national commercial problems, such as health insurance, which is a national market and something that can't be regulated very well on a piecemeal basis, which is why Congress stepped in here.
2 points. Nobody disputes that Congress can regulate the market, the business of buying insurance, the terms of insurance, the conditions of insurance. What we're talking about here, though, is compelling people to purchase something they do not desire merely because it has an economic footprint. And let me reiterate the point powerfully articulated by Justice Kennedy, who is likely to be the swing justice here. There have to be meaningful limitations under the Commerce Clause. If you say, as my colleague General Cordray says, that because a failure to purchase insurance has an economic impact, there's literally no activity known to men that would not have some economic impact that in the aggregate would impact interstate commerce. It has to be an activity. In both of them.
So you're saying it boils down, at least in part, to whether this is an economic activity.
As distinct from something that's an impact.
Yes, the court has said clearly that if an activity has significant economic impact, such as in 2005, the court upheld Congress's ability to prohibit someone from growing and using marijuana for their personal use. No economic transaction whatsoever, but they said it could affect the marketplace. That's good enough to be part of the Commerce Clause. The other point is, David says that you can't compel someone to buy a product or to pay for health insurance. But in fact, the first Congress, James Madison was part of it, passed a bill that required anybody who was going to serve in a militia to purchase a gun, gunpowder, knapsack, and ammunition to be able to serve. And then in 1798, that the Congress, with many of those same founders in it, passed a relief act for injured sailors, which required them to pay out of their wages toward a rudimentary form of health insurance before there were any insurance companies. So this is long-standing historical precedent for this sort of thing. And in fact, I think the arguments are quite out of step with modern jurisprudence.
You want to respond to that very quickly?
Yeah, very quickly. In Gonzalez versus Reich, the activity involved, growing marijuana at home in a bathtub for personal consumption, had no profit motive, but it was the same activity as growing marijuana, plantation-type setting, interstate in parks, and selling it. The same was true in the wheat case, Wickett versus Fulbright. Before you aggregate, where General Cordray is wrong, before you aggregate the impact, it has to be an economic activity. Not necessarily one of a profit motive, but an economic activity. And again, what he does, he reads out of existence Lopez and Morrison, which is 95 and 2000 case. The court said very clearly, there have to be meaningful limitations.
So clearly this is going to come down to case law, precedent, interpretation of the Commerce Clause. Let me ask you, though, both of you quickly, though, about the other argument that you make, David Rivkin, and that is it's unconstitutional to require states to set up these insurance exchanges for people who don't have insurance. Can you briefly explain to us why?
There's a whole line of cases that is basically rooted in the 10th Amendment that talks about states, again, retaining viable independent authority, which stands for proposition. And it's called New York versus United States. That case is called Prince, where you cannot co-opt states. You cannot commandeer, which is a term of art, state officials to perform tasks for the federal government. That is a very well-established line of cases. Aside from insurance exchanges, this statute would compel Florida and other states to spend billions of dollars of their limited resources, taking them away from environmental protection, taking them away from schools. That is not, even if you didn't have a mandate, that part of a statute alone is clearly unconstitutional.
Okay, well then it's 2 points, but so let me come back to the requirement, Mr. Cordray, that states set up these insurance exchanges for individuals who don't now have insurance.
Yeah, I agree with David there on the case law, but that's not in fact what this legislation does. It doesn't require the states to set up the exchanges. It gives them an option. They can set up the exchanges. If they don't, the federal government then has the responsibility to step in and set those up itself. And that's how the bill operates. Very similar to the Medicaid program. That's a voluntary program. All the states participate. They don't have to. If they do, they get federal funding and they cooperate with the federal government in the program. That's the spending David's talking about. It's the Medicaid program, and states have the option to participate or not as they please. They typically find it beneficial to their citizens, and so they do so.
Very important to underscore, Medicaid began as a voluntary effort. We would argue and are arguing that at this point in time, you cannot opt out of Medicaid. It is not a viable choice for any responsible government. Why? It would absolutely destroy the infrastructure.
But that's not a change in this law.
No,
they're expanding the number of people who would be eligible for Medicaid.
They're changing Medicaid in a way that would swamp Medicaid rolls, costing billions of dollars, quite aside from insurance exchanges, costing billions of dollars in state revenue. And remember, states cannot print money like the federal government. Having the states hire thousands of people to administer it, large chunks of a state, of this whole regulatory edifice, cannot be opted out of.
All right. Mr. Cordray,
yes, I understand. Sure, I understand the argument, but I think you're right, Judy, to point out the argument is one that the Medicaid program itself now is unconstitutional because states really effectively need to participate in it. But why do they need to participate in it? Because they've realized that it's helpful and useful to their citizens. They don't really think they could do without it. But that means they're all making the same choice. It doesn't mean they don't have a choice.
Finally, to David Rivkin, what one hears about many of the legal opponents is that truly what this is all about is an opposition to health care reform, and this is just another way of
this is
trying
unfortunate.
to
There are many worthwhile policy causes, including carrying guns near schools, after 9/11, increasing our ability to surveil the enemy. Where no matter how meritorious your policy goals are, you have to make sure you do it in a way that's consistent with our constitutional architecture. This is the American way. I frankly don't understand the argument that because healthcare reform is a good thing, which I would stipulate, that challenging it somehow is wrong. There's a serious argument. It's the Washington Post editorial page, which is hardly known.
You believe healthcare reform is a good thing?
Of course. It's the question of how it's being done from a constitutional perspective. Let me just say, Washington Post editorial page, if it's not liberal at all, said it's a serious lawsuit. It has merit. It ought to be seriously considered.